we learn from such gatherings. Today, I now know that one of the promotion criteria now in the College of Law is the level of ovation every lecturer gets from the South. And so, by implication, I'm going back to management. I should not be surprised if some of the people you have applauded this morning have double promotion from professor to super professors. Our very distinguished guest speaker today, our provosts and directors, the entire College of Law, Erediauwa staff and students present. I must remember the press that has always been here to be part of us. Very distinguished ladies and gentlemen. Here in Erediauwa University, college lectures have become our hallmark. And they have transcended the normal rituals of college lectures. And they have become transformational master classes. Opportunities where we bridge the gap between the theory and practice. And so today's lecture series that again has been transformed, excuse me, into a seminar series for very important reasons. I would like to, on behalf of our principals, the proprietor, the founder, and the Honorable Chancellor of this university, Sir Chief Dr. Gabriel Erediauwa, CFR, and this Sama of Benin Kingdom, members of council, and staff of students of Erediauwa University to formally welcome our guest speaker to today's occasion. Our guest speakers, the executive summary profile will be read later by the orator of the university, who incidentally doubles as your dean. But permit me to say that we are privileged to have in our midst one of the finest lawyers that Nigeria has produced for the global world. And so it's not surprising that the university took advantage of his presence the last time he gave a lecture here, the Honorable Chancellor's 90th birthday, to appoint him formally as a visiting professor to the College of Law, Erediauwa University. So today he will be talking in two capacities as his first guest speaker on the seminar series, but also as a visiting professor, a worthy one at that. Chief Charles Edison, SAN, is an erudite lawyer, a consummate SAN, robed in silk of the Federal Republic of Nigeria. Today, he will be talking on the contemporary issues in banking law and policy, understandably so. For some time now, the banking industry demands its care, and the laws have been evolving over time. And this paper today is going to bring an insight, instructive ones at that, on the required evolution in our banking laws. Very distinguished ladies and gentlemen, I would like to reflect a little bit on the College of Law since inception. All the accolades and the applause that we received this morning is not out of place. The College of Law is one of the flagships of this university at inception. The College of Law has produced over 3,000 law graduates. It might also interest you to know that among these graduates are also senior advocates of Nigeria. You know, at this university, we have embraced the belief that the law is not confined to ink on paper or theoretical postulates at that, but is a living instrument that shapes policy. It fortifies justice and molds a better society. As we navigate the complexity of the 21st century, I urge the students to maintain an unwavering commitment to ethical practice and lifelong learning. That is why we're here this morning anyway. It is through rigorous debate, creative thinking, and the pragmatic application of legal theory that we can cultivate a community that not only studies the law, but so actively participates in the evolution of law. Whether in academic discourse or on the streets of our communities, our legal insights must serve as a beacon of hope and a catalyst of progressive change. It is noteworthy that the performance of Erediauwa University law graduates at the law school has become outstanding, overwhelming, encouraging, inspiring, instructive, just to mention that. And this has been over the years. You will recall that in 2006, the very first college first-class graduate was among the first set of graduates that also went to the law school and made it first class. But what is our heritage there? It was the first class from a private university in the Nigerian law school because our university was the first private university to offer law in Nigeria. So you see, the syndrome of first has become the heritage of this university, and will give God all the glory. Talking about excellence beyond the College of Law, let me also give you some heartwarming information about our school Blue Sky graduates. The University Academic Excellence Syndrome remains sacrosanct and is on course. Only recently, Ms. Barakat Moritola, a graduate of pharmacy from Erediauwa University, who made a first class here, was amongst other first class interns at the Natural Resource Center in Lagos that competed for placement. She not only got the placement, but after the 1-year intensive training at the Center for Nigeria Natural Medicine Development Agency, she emerged the best intern amongst all of them. So the concept of the primus inter pares thought is not only in law, it has become the birthright, the heritage, and the treasure of Erediauwa University. We'll give God all the glory. You must applaud excellence, not just nomenclature. I say we give God all the glory. Now, similarly, this will interest you. One Miss Isa Fatima Azumi, the best graduating student in the Department of Accounting, performed exceedingly well at the November 2024 ICANN diet examination. Now listen, thoroughbred. She passed all the 5 subjects at one sitting and scored the highest aggregate. And she went home with all the 5 prizes. I'm surprised that our media team are not projecting these students on the screen. You have them in your media collection. Here in our university, as I conclude, just to let you know that we have continued to strive in the internationalization of our university. I'm sure in the next few weeks, 18 students and 2 staff of our university will be off to China for cultural partnership, all sponsored by the Chinese government. Let me just conclude by saying that I'm deeply proud of the College of Law. Yeah. I don't say what I don't mean. Your exploits have been quite extraordinary. And your performances have been superlative. Know it, and it's for real. I'm equally inspired by the timeless potential that each one of you hold for tomorrow. It's our dream that beyond the potentials as there, you must be game changers in the legal profession and global players in the field of choice that you make after now. Therefore, let us all move with courage and curiosity, creativity and innovation. Unwavering belief that the law, when practiced with dignity and foresight, remains the foundation upon which our society lives. Very distinguished ladies and gentlemen, it is now my privilege, honor, and pleasure to declare this first seminar series open. Thank you.
That the Vice Chancellor deserves a better round of applause. Ladies and gentlemen, at this point in time, I would like to invite to the microphone for the citation of the guest speaker, Professor Charles Uchim. Please, can we give him a round of applause?
Mr. Chairman, sir, please permit me to ask the guest lecturer to stand for the citation. Thank you, sir. Our protocols duly observed. The chairman, sir, we honor today a man who touches nothing that he does not adore. We celebrate today a statesman that is adored as much for the clarity of his reasoning, the richness and lucidity of his thought, the aptness of his expression, the force of his logic, and the reasonableness of his conclusion. I present to you Chief Charles Wesuyi Edo-Sonwo, Senior Advocate of Nigeria, former Attorney General and Commissioner of Justice, Edo State, Fellow, Chartered Institute of Arbitration, UK, the Obasuyi of Benin Kingdom, and a visiting professor, College of Law, IOU, Okada. Ladies and gentlemen, the Shakespearean logic of greatness is anchored on the tripod stance. Some are born great, some achieve greatness, and others have greatness trusted upon them. In the case of Chief Edosonwo, he achieved greatness by dint of hard work. Chief Charles Uwesuyi Edosonwo has a rare greatness, but it's not a greatness that is faultless. Like all great men, he's a man of paradox. Simple without being simplistic in disposition, but regal and dignified in courage. Yet, he relates with the ordinary person, as his life is totally devoid of guile, undue pomposity, and elitism. A dogged fighter of whatever cause he believes in, yet an astute master of the act of reconciliation, an Edo man to the core, true to his root, and indeed very proud of his ancestry. But at the same time, first and last, a Nigerian. To Chief Edosonwo, nationalism is an exciting commitment to Nigeria and a celebration of his variety. His life is indeed one huge landscape of courage that does not intimidate others, generosity of mind that does not vaunt, and a loving kindness for people that have risen triumphant over his human frailties. Chief Charles Edosonwo arrived planet Earth via Benin City on the 10th day of May 1960 to the family of Prince Osasuyi Uwesuyi Edosonwo, a renowned surveyor and town planner, and Princess Veronica Uwesuyi Edosonwo, a civil servant. Chief Charles Edosonwo attended Government College Ughelli, Delta State, for his higher school certificate, where he graduated with distinction. He attended University of Lagos, where he bagged BA Philosophy. In order to become a learned friend, as he is today, he thereafter proceeded to University of Benin for another degree, this time a law degree, where he bagged LLB with honor. He was called to the Nigerian bar on 20th August 1985. Like the saying goes, a man who wants to lead the orchestra must turn his back on the crowd. Chief Charles Uwesuyi Edosonwo, despite his unparalleled achievement in the legal field and the comfort associated with it, went back to University of Lagos and obtained an MA Philosophy in 2004 and a PhD degree in Metaphysics and Philosophy of Law in 2023. Here indeed lies the strength of his advocacy prowess and communication, as you will see and hear shortly. Charles Edosonwo commenced his working experience with the Federal Ministry of Justice, Lagos, during his primary assignment as a youth co-op member between 1985 and 1986. And armed with sufficient knowledge and practice, he registered his law firm, Uwesuyi Edosonwo & Co., after his national youth service in 1986. And the law firm has turned out great legal minds under the direct tutelage of our great senior advocate. Having contributed much into the private sector, he decided to forage into politics in order to contribute his quota to Edo State. Hence, in 2003, he was appointed Attorney General and Commissioner for Justice, Edo State. Chief Edosonwo no doubt hate ignorance with a passion and attack it from all fronts. He himself had unquestionable taste and appetite for knowledge. He has attended several conferences and presented several papers in international commercial arbitration, law and practice of intellectual property, special fellowship course, both home and abroad. In fact, the list is endless. As a writer, his capacity for intellectualism is unassailable, his logic impeccable, and his scholarly depth unmistakable. It has been said that when historians write, he records past events. When activists write, he turns ideology into action. When a philosopher writes, he probes the depth of knowledge. And when literary artists write, he pens beautiful literature full of facts and fancy. But when Chief Edosonwo writes, he integrates the skill of all this into a symphony of finished product. Indeed, he conjugates art, law, and philosophy. In recognition of his excellent performance at the bar, he was conferred with the rank of Senior Advocate of Nigeria in 2000, the highest rank of distinction in the legal profession by the Legal Practitioner Privilege Committee. He is the first alumnus of University of Benin to be conferred with the rank of San. In 2003, he was also appointed Attorney General of Edo State and the first senior advocate to become Attorney General in Edo State. He is also a proud recipient of African Bar Association Medal of Merit in Leadership, which was presented to him by His Excellency Dr. Makati Shaskwera, President of Malawi, on Monday, 8th of August, 2022. Other positions held include but not limited to the following: member, Edo State Judicial Service Commission; member, Edo State Security Council; member, Council of Legal Education; honorable member, Body of Benchers; honorable member, honorable life bencher. Chief Edosomo is a member of the following learned association: Nigerian Bar Association, Maritime Law Association, Chartered Institute of Arbitrators, UK, Market Lawyers Association, International Bar Association. Chief Edosomo had many honors conferred on him: Alumnus Award, University of Benin 2000, Lifetime Achievement Award, University of Ibadan 2018, LID Honor Causa, University of Benin 2023, Obasuyi of Benin Kingdom 2014. He is versed in several areas of the law, including election petition, maritime law, arbitration, oil and gas, among others. Sir, you have moved mountains. Little wonder that you have been equated with the likes of William Du Bois, Marcus Garvey, Nelson Mandela, and Martin Luther King Jr., all of whom, like you, care passionately for their fellow men and women. You have indeed walked in the sun-flooded lane of the legacy of revolutionary lawyers like V.I. Lenin of Soviet Union, Fidel Castro of Cuba, Oliver Tambo of South Africa. Like these men of conscience, you are a barrister of justice. Like them, also, you have been branded with demonized images. Your virtues, your noble character, your true patriotism, and activism has secured for you an immortal name. The fire of your mind is so intense, penetrating and ardent, if not suffocating. You are no doubt a man of destiny. You belong to the history of Nigeria. We salute your heroic courage, your dogged conviction as a person, and tenacity of purpose as a lawyer. Ladies and gentlemen, you'll be giving humanity a great honor if you give him a standing ovation. Standing ovation, please. As I present to you the Obasuyi of Benin Kingdom, a senior advocate of Nigeria, a professional in politics, a good Christian of common favor, a devoted, loving father, a dedicated husband, a visiting professor of law, a successful legal practitioner. With the permission of the chairman, I humbly invite this lawsome son of the soil to the podium to deliver his lecture titled Contemporary History in Banking Law. I thank people for attention.
I think before I start, let me pay gratitude, deep gratitude to the orator, Mr. Charles Oche. But I don't want any of you to think it was me he was talking about. I'm not all that. I'm not all that. I'm really, Mr. Oche, I'm very, very flattered. And I thank you for your kindness. I'm sure you did that with a lot of kindness. But I'm just a humble lawyer who likes to interact with these our precious children, gifts from God, our leaders of tomorrow, our fathers and mothers of tomorrow. I thank you. You know, when things are said about you in the public space, if you don't say anything, you are endorsing everything that I said. You're endorsing everything that I said about you. I just want to correct one fact. I was in the University of Lagos to study philosophy. You want me to do something? Not me? Oh, him. Okay, because you are distracting me. I was in the Department of Philosophy for 1 year. 1 year. And it was a very great time. Regrettably, when we were starting the second year, Guess what? My mom marched to the University of Lagos and yanked me away from there. I said, we want you to be a lawyer. You know, you women are very tenacious, especially Asian women. They're very fierce when it comes to their children. Are there any Asian women here? A round of applause for Asian women. Of everything you said, that is the only thing I want to, apart from the fact that the larger than life is not me, but I needed to correct that. Mr. Vice Chancellor, distinguished faculty, including the Deputy Vice Chancellor, Dean of Law, professors, university honchos, the bursar, the registrar, and the distinguished, beautiful students of Erediauwa University. Are you authentic? Great. I thank the university for, even though I'm unworthy, for making me a visiting professor. And I made a commitment to my friend and brother, the Vice Chancellor, Professor Ezemonye, and the Chancellor of the university, that I will do my best. For me in life, there's nothing called a sinecure. Let me just answer the name and enjoy the prestige. Outside here, I probably won't call myself professor, but here, today, I'm a professor of the university. I didn't answer doctor when I was given an honorary doctorate degree by University of Benin, but I'm answering a doctor because I also have an end PhD. Nigerians must learn to forget the pizzazz and face the substance. That is why I've aligned myself with the ambitions of the Vice Chancellor, who correctly says that and thinks and acts it that a university education is just not a matter of being bookish, theory, and all that. You must see the pragmatic side of things. So when I had the rare privilege, which I'm most grateful of, coming to speak to you again today, we decided that we will establish, with the permission of the Vice Chancellor and University Administration, what you call the Erediauwa University Law Seminar Series. Seminar Series. So it won't just be only me coming to talk all the things to you. We will bring accomplished people here too to also be part of it. It will be a seminar, interactive seminar. You will hear things that you probably haven't heard before. And you see perspectives that you probably haven't seen before. For instance, by the time Professor Nelson Ogba finishes his talk on know your customer, the KYC rules, you will understand why some of you, your fathers will say, oh, I sent you money days ago. I sent you ₦1 million days ago into your account that you normally get 50,000. And you will be telling you 5 days afterwards, I haven't received it. I haven't received it. But I send the money, that's your father speaking to you. Then he will get back to his bank. And the bank will tell him that, look, that account we are sending it to, we had to report it to the Special Committee Against Money Laundering, because that account has not received 100,000 naira before. All of a sudden, it's receiving 1 million naira. It is part of the know your customer rules. Part of the what? Know your customer rule. So if you didn't know, your first instinct would be, let's sue this bank. What the heck? How can you hold my money? The banking contract between you and my father. He sent the money, and for you not sending it, the breach of banking contract. No. The pragmatics today will tell you the reason why it wasn't sent was legitimate, in line with laws of this country. The most recent is the Money Laundering Preventive and Prohibition Act. Before it used to be the Money Laundering Prohibition Act. Now you have called it the Money Laundering Preventive Prohibition Act, MPPA. All that you will find out, you will see. Let us not waste too much time. I'm going to give a talk later on. But first of all, let's kickstart this program by calling to the podium Professor Emeka Chianu, who will talk to you on today's delivering 2 papers. Please, I advise you, law students, whether you've studied banking or not, keep your ears quite open. When Professor Chianu speaks, he comes with a lot of wisdom, nuggets that you must keep in your bag of tools that should remain with you all your professional life. He's a rare one, an accomplished academic, a law professor that should be a lot more, if not for his humility. A round of applause for Professor Chianu.
Thank you, IT man. So I think I can talk straight from here. My Vice Chancellor, Professor Lawrence Ezemonye. Just to be brief, I've known him for over 34 years. I joined the University of Benin in 1991, and I met him there. He was one of those who made me feel at home in the University of Benin. I will encourage everyone here, both staff and students and management, to endeavor to keep him, because from here, he is moving on to become either a minister of the Federal Republic or vice chancellor in a larger university. Our chief lecturer today, Chief Charles Uwensui, SAN, everything that has to be said has been said about him. I'm sure that you will enjoy more and more interactions with him as this seminar series continues. And then the Dean, Professor George Erediauwa. He was in my first class in the University of Benin in 1991. Am I right? Yes. And I'm very happy that he's doing well. So let's get straight to the point. I'm talking about freezing of bank accounts. Now, for the purpose of the young students who will become great lawyers tomorrow, I'll mention 3 basic banking principles. One is that when a person deposits money in a bank account, the money belongs no longer to the customer, but to the bank. It's a fiction of some sort. It remains your money, but in the eye of the law, the money belongs to the bank. The second principle is that a person is not entitled to the money he has kept in the bank until he makes a demand for the money. So he has to prepare a withdrawal slip or draw a check, and then it is only then that the bank is obliged to pass the money on to him. Under normal debtor-creditor system, it is the debtor who should go looking for his creditor to pay him. I'm owing you, I want to pay you. But in banking system, it is the customer, the creditor, that will go searching for the debtor, the banker, to say, please pay me. The authority for that is one English case, 1921, Joachimson, The Jackimson was a member of a partnership. The partnership was winding up, and then he applied to the bank to be paid the balance in the credit. And the bank said, you have not drawn a check. You've not drawn a dry slip, so we're not obliged to pay you. Jackimson was angry. He went to court, but the court ruled in favor of the bank. The third principle was enunciated in 1924 in a case called Tonia. In Tonia's case, Lord Justice Bankers mentioned that the bank must learn to keep secrets. And that goes without saying. If you kept 1 million naira, as Chief Wensui said, with your friend, and the next moment your friend goes from door to tell people that Tony has 1 million naira and he kept it with me, I'm sure you'll not be happy. So banks are taught to keep secrets. So nobody knows how much you have in the bank. But out of that principle, we have 4 exceptions. We want to discuss just 2 of them. Namely, on account of the law. If the law says the bank should tell the world how much you have, the bank must comply. And secondly, on account of public policy. We can go to the next slide, please. Now, you imagine that if banks have to keep secrets, they may keep secrets that the public will want to know. For example, Professor Nekachi Ano has 5 million naira in his bank account. Public servant, university lecturer, where did he get 5 million naira from? The public may want to know. Law enforcement agents may want to know. So that obligation for the bank to tell the world how Chiano got 5 million naira will have to be explained. Now, in 1879, the Bankers Books Evidence Act was enacted. That act was designed to ensure that if Chiano has a case in court and it's because I have a bank account, the bank must come and testify. They bring their ledger. You are not familiar with ledgers because you are young, but older persons are familiar with ledgers. They are large books. They have to carry the ledger to the bank, to the court, and the court will have to flip through. And as long as the ledger is with the bank, with the court, the bank cannot carry on its business. So in 1879, this act was enacted. The object is you can go to the bank, take records of what is in the ledger, and then bring the records to the court to tell the court what is in the ledger. You don't need to carry a whole ledger to the court. Now, over the years, unfortunately, in Nigeria, not in England, where the law was enacted, in Nigeria, police have been using this Bankers Books Evidence Act to freeze bank accounts. Now, this is how it works. If, for example, I'll use Professor Nwazi as an example. I'm sure he will not be hurt. He was my student. If, for example, I go to the police to tell the police that Professor Nwazi has 5 million naira in his account and he stole the money from, give a name that you like. Now, Nigerian police will go fill a form when the book is published, as our visiting professor said, when the book is formed, you see a specimen of the form. The form is very simple. They keep it in the police station. They just fill the form, take it to a magistrate or a high court judge, and then the high court judge will just stamp and sign without asking questions. Now, that form is sent to the court. It's sent to the bank, sorry, where Nwazi keeps his money, and then the account will be frozen. So when Nwazi seeks to withdraw 5,000 naira or 2,000 naira or 100,000 naira, the account is frozen. They did that, they've been doing that for how many years? But they did that against Onoguruwa. Onoguruwa was the Attorney General of the Federation, was senior advocate, was chairman of the Nigerian Bar Association at the time. So he had a firm, and then the account was frozen on account that they felt that some money in that account was stolen from the client. So Onoguruwa went to court, and then the Court of Appeal said that what the court did and what the police did was wrong, and the account was unfrozen. It was also done in Société Générale and Afekoro. Actually, in Société Générale and Afekoro, not only was the account frozen, but the police directed the bank to transfer the credit in the account to another person. And the bank complied. And then, of course, the customer went to court, and the matter went all the way to the Supreme Court. And Afekoro won. The customer won. Unfortunately, the Supreme Court did not seize the opportunity to make a pronouncement that the police have no authority to use the Bankers Books Evidence Act to freeze account. It is only for the police to obtain information from the bank and tell the court in the course of prosecuting the person. One other thing about the Bankers Books Evidence Act is that there must be a legal proceeding going on. There must be a case going on. Either a civil case or a criminal court case must be going on. You cannot use the act to go and obtain information before you charge a person to court or before you bring up an action. Section 10 says there must be a legal proceeding going on. You cannot use the act as a search warrant. Next slide, please. So that in 1966, of course, you know that January 15, 1966, there was a coup, and one of the objects of the coup plotters and so on was to check corruption, bribery, extortion, and abuse of office. So in 1966, Banking Amendment Decree was enacted or promulgated. The object of the act was to give the head of state authority to freeze accounts, but it was for a maximum of 3 months. That's one good thing about the decree. Account is frozen for a maximum of 3 months. In 1969, there was an amendment that extended it from 3 months to 1 year. And then the law provided that even though the account is frozen, the account holder, that is the customer, can withdraw a maximum of £50 per day. So the good sense in that is this. Although your account is frozen, you can still get a little money to survive 1 day at a time while the investigations are on. Well, in 1979, next slide, please. In 1979, we had civil rule. The civil rule was truncated in 1983. In 1984, the military came back and then enacted another Banking Amendment Act and so on. We can't go into all of that. Let's go to this present slide. That's the NDLEA Act. Now, in 1989, the NDLEA was enacted to check trafficking in drugs. The act enables the chairman of the agency to freeze accounts if he suspects that a drug trafficker was running the account and then money was inside the account. But he must get the approval of the Attorney General of the Federation. Now, this is odd because all the other acts provide for obtaining the approval of the court. But this act says approach the Federal Attorney General to get his nod or his approval before you freeze an account. 2, the act says this can be done only when a person has been arrested. If he has not been arrested, you can't freeze his account. Unfortunately, lawyers are able to find a loophole in the act. There's a similar statute in England where the Nigerian statute was copied from. Now, that statute provides that if money is found in an account, the account should be frozen. Now, suppose I have 500,000 naira in my account from my salary. And then from drug trafficking, I have 2 million naira. So my account balance is 2.5 million. But the money on drug trafficking is 2 million. My own salary is 500,000. So in the case you can see on the slide, Chief Constable of Hampshire and A, we have to hide the name of the person because he's an accused person. We don't publicize the name. So as students, we see A, T, and so on. The law permits the secrecy of the accused person. The English court said that if the credit in the account is mixed good money and money from trafficking, you cannot freeze the account. So we want to see if Nigerian courts will follow this precedent. Now, what Parliament can do, as suggested in the paper, is that they should just add the phrase, or any part of the fund, or any part thereof. So it's either the entire 2.5 million or any part thereof. So if you have any part thereof, then of course, since 2 million is part of 2.5 million, then of course the account can be frozen. That's one of the suggestions in my book. The next, so the Advanced Fee Fraud and Other Fraud-Related Offences Act 1995 was the next statute that looked into the issue of freezing of accounts. Again, account may be frozen only when trial is on. And it is not intended to obtain information to charge a suspect. You must have gotten information about him, charge him to court before you can freeze the account. And only the High Court may freeze account under this act, not magistrate's court. The next one is the EFCC Act 2004. Now, under this act, officials may use an ex parte application. Law students should know what ex parte application means. You don't tell the other party that they are going to court. So, ex parte application to freeze an account. So, the officials of EFCC may just go to court. We want to freeze Chianu's account. He's into advanced fees fraud or into economic fraud. So give us an order. And then the court will give the order, my account will be frozen. So going to court to obtain an order to freeze an account is a check of some sort on the excesses of EFCC. Unfortunately, in GTB and Erediauwa, officials of EFCC did not go to court to obtain an order. Officials of EFCC just went to GTB, please freeze the account of Erediauwa. And there were actually two accounts. The two accounts were frozen. Erediauwa got to know, and he went to court. And then the matter went up to the Court of Appeal, and the Court of Appeal said GTP was wrong, that they should have ensure that EFCC obtained a court order before freezing the account. Now, this lecture is not only about the law, but also policy. So let's look at the policy. Is it for the bank to question what EFCC is doing? If a bank manager says, I am not going to freeze an account, take this paper away, go and obtain a court order before I can freeze account. We're Nigerians, we're in Nigeria. Can you imagine what will happen to the bank manager? He could be arrested, isn't it? The branch may be sealed by EFCC. And if a bank is sealed even for 1 hour, the goodwill the bank has may go lightly. So the bank is in a dilemma to obey EFCC that has not obtained a court order or to comply, blah, blah, blah. Now, an interesting point is that about 30 years earlier, in Barclays Bank and Taylor, a similar issue had arisen in England. So let us see what the English court did. Taylor were husband and wife. They had an account. There were suspicions that fraudulent money were in their money was in their account. So the police did the right thing anyway, got to the court, got a court order, and froze Taylor's account. Taylor went to court to challenge what the bank did. And his argument is that the bank was obliged to tell them that the account had been frozen or that the account was being investigated. It was not enough for the bank to comply without telling the customers. So that was the core of the argument of the Taylors. But the Court of Appeal said that is not part of a bank's duty. The bank should comply with a court order. It's not part of his duty to tell the customer that your account is being investigated or your account has been frozen. A similar issue arose in IBWA and Kennedy Transport. Again, using the Bankers Books Evidence Act, which we mentioned earlier. Now, in this case, IBWA, the account of Kennedy Transport Limited was frozen by the police. IBWA was kind enough to inform the customer, your account has been frozen. Rather than chase the police that froze the account or ordered the freezing of the account, the customer went after the bank. The managing director of the company drew a pay cash check, dropped the check with the bank. Of course, the bank dishonored the check because the account had been frozen. And on the basis of that, Kennedy Transport went to court. But the Court of Appeal said the bank was right by complying with the order of the police. If the customer is dissatisfied, the customer should learn to proceed by way of certiorari. I'm sure that the law students who have passed through 300 levels know what certiorari is. Am I speaking Latin? No, if you're in 300 level, in 200 level constitutional law, administrative law, I'm sure you have been taught certiorari. They should proceed by way of certiorari to annul the court order or the order of the police and the court order if it's magistrate court rather than go after the bank. Before we talk about money laundering, again, we want to talk about a policy issue. Police, from what the courts are saying, police have no authority to freeze account. They have to go through the court. The question is, if the police go to court to obtain court order and the customer gets to know, what do you think will happen to the credit balance in the account within 24 hours? The money will be withdrawn. So we have to decide on grounds of policy, what do we want? We want the privacy of bank customers to remain, or we want to fight crime and fraud. The Nigerian society must decide on this issue. Nigerian courts must decide. The preponderance of opinion in England is that we must fight crime first, public policy, before the private interest of account holders. Whether Nigerian courts will follow that, we don't know. Adedamola was praised by my former student, Douglas Ogbonka, as Professor George will know him. Douglas Ogbonka, he writes a lot in WhatsApp and so on. That was a good judgment. But if you ask me, if our goal is to fight crime, fight fraud, check corruption, then the Court of Appeal did not do well by insisting that the bank should tell the customer, because the customer would remove the money and you cannot trace the money. Now we come to Money Laundering Prevention and Prohibition Act, which our visiting professor mentioned a moment ago. Here, and then Professor Ogba is going to talk about that, so I'll just be brief about that. He said that once you find sum of money exceeding $10,000, $100 million, I think it's $10 million, $10 million, corporate account, $5 million, private account, then the bank must tell the special unit of EFCC, and then the special unit will apply to court within 72 hours to get a court order to freeze the account. Again, with many persons feel that's the most recent statute on the freezing of accounts as far as my research goes. Again, we go back to the issue. Will EFCC comply with this a period not exceeding 72 hours? Now, only the Federal High Court has a jurisdiction. Now, we know that Federal High Courts are not everywhere. There's no one in Okada here. Why go to Federal High Court? Why not State High Court? So that it will be speedier. Those are some of the issues that will be discussed by policy considerations. The last slide, please. Generally, banks do not have anything about freezing of accounts. The reason is that the money remains with the bank. The more money the bank has, the happier the bank is. Because occasionally the CBN wants to know what is your liquidity ratio? How much do you have? And banks want to retain money. So if there's a freezing order, it's to the advantage of the bank. 2 or 3, sometimes the customer is exasperated. He may die while the account is frozen, and his children and relations may not even know that he has an account. So the money belongs to the bank, blah, blah, blah. Alternatively, the customer may be exasperated, going to court, going to police, going to EFCC, and so on. And then he leaves the money in the bank, and the bank gains. So ultimately, freezing the bank accounts largely is for the benefit of the banking system. The customer is hurt, but if our policy is to fight corruption, curb fraud, curb crime, I think the law enforcement agents can do better. The court system can do better. The last slide, I guess. I want to thank you all for giving me attention. I'm sure you have comments.
A round of applause for Professor Tan. Now, let me tell you, he's going to come back with another paper. But I noticed that even your vice chancellor is taking notes. I see a lot of students not taking notes here. These things, you are here to learn. Don't leave here without imbibing things. Because these are rare nuggets, like I told you. You know, this power to freeze accounts, the bank's conduct with accounts, you know, it's something that's key to our business transactions. And everybody must be keen to learn most you can learn from it. So, coming from Professor Channel, he's an authority in this area. I think the best you can do, emulate your vice chancellor, who is an environmental toxicologist, who's taking notes. Maybe he wants to take my job from me tomorrow. but that's the idea. I will call on today is for this is a seminar in business law, and we're actually the banks today, banking regulations, banking operations, policies, and principles. The next speaker, Professor Kalu, has done some works on, if you've heard about the Know Your Customer precepts. It's an international thing that has been internationally promulgated. Member countries of democracies have plugged in to use in sanitizing the banking processes so that it will be difficult to use dirty money to either finance terrorism. You see that all these so-called headsmen, they tote their AK-4s, some carry RPGs, propeller grenades, and they have also sophisticated communication equipment. They can talk to coordinate with themselves. They even have equipment that our police don't have. You know, how are they financed? How? How do they buy their material? How? Their ordinances, how do they buy them? I can tell you, I don't see an AK-4 costing less than $1 million in the market. The one you see them casually slinging on their shoulders, you know, and the bullets, the ordinances they use in firing them, they don't come cheap. How are these ordinary looking men who have no education, they're not sophisticated, how are they able to acquire them? It's terrorist financing. The anti-money laundering policies and principles are supposed to attack those things and plug them. So they dovetail into matters of the privacy of the customer, the proprietary ownership of the customer, of his funds, the operations of the bank, rights, government. Everybody's involved in it. how do they play out? I introduced to you Professor Oba, Nelson Oba, another accomplished academic that I think you should feel privileged to be to today. Nelson Oba, please.
Mr. Vice Chancellor, sir. Leonard Sikh, the visiting professor of law, the principal officers of the university, Igbenedion University Okada, all other protocols observed. Because of time, we will do our work in outline. The detailed paper will be published by the Leonard Sikh subsequently, probably in your university publication. Today, we are looking at the contemporary challenges and expectations in banking regulation in Nigeria, with particular reference to the Special Control Unit against money laundering, which normally is called SCOMIL, as a panacea to money laundering and compliance issues. Next. Okay, so in the abstract, we are looking at effective banking regulation is fundamental to the strength and stability of any economy. Without a stable banking sector, the economy will be in shambles. That is why there's a big difference between countries like United States, Nigeria, as opposed to Somalia or Sudan, where the system is not resilient. So one of the fundamental objectives of banking regulation is the enthronement of an efficient regulatory mechanism for prevention of our containment of money laundering, because money laundering is detrimental to the economy. Now, influenced by that, the countries of the advanced economies and the emerging economies have enacted laws to regulate or contain money laundering. Now, in Nigeria, that has influenced the enactment of the EFCC Act, the Money Laundering Act, the Terrorism Prevention Act, like the Leonard Sikh already mentioned. Now, the paper identifies money laundering as a major problem to the economy, and particularly gives attention to the Special Control Unit against money laundering, which is the crux of anti-money laundering measures. Now, as we will see later, it is obvious that Nigeria is not lacking in the array of laws to regulate money laundering. But we ask ourselves, have these measures been effective in checking or containing money laundering and terrorism financing? So in the introduction, like we have, please the next slide. In the introduction, we are saying that effective banking regulation is key to the resilience of any financial system. Of course, a lot of authorities have heard of that opinion, including Solari and Emme, then Poll 2020. Then that has led us to the opinion that targeted banking regulation engenders safety, transparency, stability, and reliability of the banking system. Now, we brought out two test cases to buttress our position. The first one is the case of the Bank of Commerce, Bank of Credit and Commerce International. Most of you in this hall, like the students, might not know about this bank. But this bank was founded in the early 80s. by a Pakistani investment banker, Aga Abedi. He floated this bank in Pakistan and the United Kingdom. It became the toast of the moment at that time, the BCCI. It was a popular bank all over the world. In fact, it had a branch in Nigeria, BCCI. But as you will find out later, the problem of money laundering consumed that bank. And today, the bank is no more. So, pointing to the fact that it is important that states or countries maintain an effective regulatory mechanism for checking money laundering. Now, the second one is the Barings Bank crisis. Now, Barings Bank was a bank founded in 1763 in the United Kingdom. It's operated all over the world. But unfortunately, one staff, you have the name there, Nick Leeson, just a trader, an investment trader for that bank in Singapore, was involved in money laundering to the tune of 1.3 billion US dollars. And that was what led to the death of the Barings Bank. Now, it might interest you to know that this bank was so popular that the Queen of England then, Elizabeth II, banked with the bank. But money laundering led to the failure of that bank, which means the position held by some or most people that there must be an effective regulatory mechanism for checking money laundering is very apt. Now, how to tackle this? We say that check on money laundering and terrorism financing is apt, and that's the opinion of Adebanjo. Then prevention of contagious cross-border implications of money laundering is very important. That's the opinion of Ojukwu 2015, Oluwadaisi Amemiko 2016. Now, to achieve the objectives of effective banking regulation, the state has adopted, like I said, the anti-money laundering and countering of funding of terrorism. The measures are what have influenced what you have as the AML and FT measures that led to the enactment of some of these laws, the Money Laundering Act, the FCC Act, and the TPA, that's the Terrorism Finance Act. Okay, so we look at money laundering and the challenges and the implications. Now, this is very important for students of law, especially persons offering banking, law of banking and negotiable instruments. We start with a pervasive, the problem is, that's the challenges. They are pervasive and complex, therefore difficult to contain. How do you contain these challenges of money laundering? And we have identified the negative effects of money laundering. We say it poses grave risk to the financial sector stability. Now, it is so epitomized by the activities of the PEPs. PEPs are publicly exposed persons. Publicly exposed persons are persons who have held public offices. And they, in the course of doing their jobs, help themselves to the national till, to the public till. Now, we also identified that the money laundering activities also distort administration of the financial system. Then it adversely affects government revenue because there will be leakages when practitioners are involved in money laundering. Then we also identified that it breeds cross-border financial crime. Cross-border financial crime are cross-border illicit movement of money or funds from one jurisdiction to the other without allowing it to pass through the right channels, which would be the treasury of the country. Okay, and we also identified that it undermines good governance. Then Nigeria's image will be adversely affected in the process. The next slide, please. Okay, so Nigeria image and reputation will be affected in the international scene. Then it causes disincentive to the attraction of foreign investment. When foreign investors are not sure of the stability and transparency of the economy or the financial system of a country, they will be reluctant to invest. Now, it undermines national security due to terrorism financing. Like the learned mentioned earlier, what we have in the Northeast and Northwest are symptomatic of the challenges of terrorism financing, because it doesn't bode well for any country if allowed to fester. Next slide, please. Okay, so we're looking at the legal and institutional frameworks for containing money laundering in Nigeria. Having identified these issues, what are the steps needed to be taken or what have been taken to check money laundering? Now, we start with the Financial Action Task Force. Now, this is a body that was constituted as far back as 1989 to fight money laundering when it started rearing its ugly head at the international scene. The FATF, which is the catalyst of our discussion, is an independent intergovernmental body formed in 1989 by the G7 in Paris. G7 is a group of 7 industrialized countries. They came together to tackle money laundering, and in the process constituted what became known as the Financial Action Task Force. Now, it was formed to play the role of a global watchdog against money laundering. However, in 2001, the organization now elevated its work to also include financing of terrorism after the 9/11 episode. For some of you that might not know, the 9/11 episode was the bombing of the World Trade Center in New York that killed almost 1,000 persons. The best crop of brains in the financial world were based at the World Trade Center. That these terrorists hijacked planes and flew into the World Trade Center and the Pentagon, killing several persons. So this aggravated the crisis in the international finance scene, which now led to them, the FATF, incorporating terrorism financing as part of what they do, what they regulate. Now, this organization or this agency develops and promotes policies to protect the global financial system against money laundering, terrorism financing, and other related crimes. They developed templates or recommendations which was supposed to be adopted by countries. It was not a hard law. It was a soft law presented as recommendations or models for countries to adopt in enacting their laws against money laundering and terrorism financing. Now, Nigeria, like most modern states, adopted these FATF recommendations to enact the anti-money laundering and countering of financing of terrorism laws and specialized institutions. And that among that will be what you have as the Money Laundering Prevention and Prohibition Acts of 2022. The Terrorism Prevention and Prohibition Act of 2022, the EFCC Act of 2004, which gave rise to the EFCC as a commission to regulate the anti-money laundering laws. Now, you ask yourself, Why did Nigeria go to this extent to enact laws on money laundering? The governments of the day, the governments of Nigeria and other emerging economies, didn't just accept to enact these laws. They were coerced. They were coerced into, or I'm twisted to do it, because the fear of being listed in what was called the blacklist or the gray list was what influenced that. Now, the blacklist is a list maintained or a documentation maintained by the FATF for countries who are reluctant to cooperate in adopting these recommendations to make laws to prevent money laundering and terrorism financing. If you are reluctant to adopt or make laws to tackle that, then you will be considered a state hostile to the global effort to prevent money laundering. And you are listed as a state under the blacklist. It means the international finance world will not have any business to do with you. And you know the implication. Your exchange control will fall into shambles. Now, the fear of that being listed as under the blacklist or gray list influenced Nigeria and other countries adopting and enacting laws like we have identified. So we look at the laws that were made, influenced by the FATF. We start with the Money Laundering Prevention and Prohibition Act of 2022. Now, this law was tailored after the framework of the FATF recommendations, like we have said. It was first enacted in 2003. Then a new version took over 2004. Then 2011, until what you have today as the MLA 2022, which repealed the 2011 Act and replaced it with what you have as the Money Laundering Prevention and Prohibition Act of 2022. Now, this law forms a key framework for the anti-money laundering and countering of financing of terrorism measures. It was enacted to form the crux of the fight against money laundering and by necessary implication, terrorism financing. Now we'll look at some of the basic provisions of this law. We'll look at Section 11, subsection 1A and B. Like the first speaker, Professor Chanu, said, it is a mandatory requirement for financial institutions and non-financial institutions and businesses, including the professions, to report on transactions of 5 million naira and above for private individuals and 10 million and above for corporate bodies. It was a mandatory requirement. Now, the implication is any agency or any financial institution that did not report, or any professional operating with persons who transact in financial business, not reporting must have committed a criminal offense. But you ask yourself, how many persons have been prosecuted on this? Every day we hear of millions and billions discovered in banks against certain PEPs, publicly exposed persons. Now, you ask yourself, have these laws been enforced, or are they enforcing the law the way it should be? Then I also refer ourselves to Section 11, subsection 2A and B. Now, the requirement on that is that for any transaction 1 million and above, individuals are obligated or encouraged to voluntarily inform or notify the authority that these transactions have been made. For private individual transaction, or 5 million naira for corporate bodies transactions. But we ask, are they complying with the law? Now, the next one we must look at is, under this Money Laundering Act, the provision of Section 17, Subsection 1, which created the framework for the establishment and operation of the Special Control Unit for Money Laundering. Now, it was enacted to check money laundering, and under Section 18, it defines money laundering. Then it also enacted associated offenses. It empowers the Attorney General to make regulations for the efficient implementation of the MLA. So let's look at the next slide, please. The EFCC Act, which was first enacted as the EFCC Act 2003. Then it established the Economic and Financial Crimes Commission. It was initially considered the Financial Intelligence Unit for Nigeria, because that was what was contained in that FATF recommendation, that each country must have a financial intelligence unit. So this law that created the EFCC empowered the EFCC to be responsible for enforcing the provisions of this other array of laws: MLA, Advanced Fee Fraud, Failed Bank Act, both here, that's Banks and Other Financial Institutions Act, and all that. You ask ourselves, are they enforcing that? Are we having an effective regulation of banking? Then, please, the next one, next slide. Okay, so two that they are enforcing is the Terrorism Prevention and Prohibition Act of 2022. We repealed the TPA 2011, provides comprehensively inter alia for effective CFT measures. That's countering of funding of terrorism. It prohibits all acts of terrorism and terrorism financing, and punishes terrorism financing. Then it also punishes attempts. Even attempts, mere attempts, will be punished under that act. The next one. Please, next slide. Okay, so the Special Control Unit Against Money Laundering is the main institution established as the Financial Intelligence Unit for Nigeria, and it was established in 2005, modeled after the FATF recommendation, administered under the regime of MLA. So Section 17 to 18 provides on what the functions of the body. Now, let's go to the next slide, please. We'll look at the anti-money laundering and counter-terrorism financing, interrogating the compliance issues. What we're saying, having considered those laws, can we say that the enforcement has been effective? We think that is not so. We say there are challenges despite the clear provisions of this act. Then the collateral criminal liability enacted and all that have been overlooked most of the time. What we see EFCC enforce are pursuit of so-called Yahoo boys. But the main problem has not been tackled at all. The main problem is the practitioners in the business who are supposed to be monitored, who are not being monitored. Now, with time, in the main paper, we will look at the implications of the Court of Appeal in the case of CBN against registered trustees of MBA. Please, next slide, please. So we have now recommended some measures. So we say more effective actions are needed to achieve the desired objective for the creation of the SUML, and it should be unbundled because the Special Control Unit is a division under the EFCC. We have the opinion that it should be unbundled and made a unique and distinct agency of government to tackle money laundering and terrorism financing. Okay, so the next slide. Finally. Okay, so in conclusion, the menace of money laundering and terrorism financing is overwhelming in Nigeria. And the measures to tackle that is underwhelming. It's obvious. And the enforcement mechanism might be a major problem. We have identified political will of the government to challenge these issues. Then in the main paper, the details of this will be available to you when the learned will now and the faculty will publish it. Thank you very much.
Hello. Please, a lot more for Professor. Well, you are good. Everybody's going to get involved. It's going to get involved. You have questions. There'll be time for you students to ask questions. Short time for you students to ask questions. But feel privileged to have listened to Professor Nelson Ogba. Now, there's one more paper, and we'll be done. I have to bring back Professor Chanu. Yes. Come and talk about
E-banking.
e-banking. Listen, guys, e-banking. You better just keep your ears open. This is the 21st century. Thank you.
Yeah, sure. We want to thank Professor Nelson Ogba for his fine paper. Professor Ogba is the first PhD holder in University of Benin who had a post PhD fellowship, and he got a place in South Africa where he spent 3 years. Before we had to beg him to come back to Nigeria. So thank you very much, Professor Ogba. So let's go to the next slide, please. We'll see if we can get that done in less than 15 minutes. 10, sure. Yes, so e-banking, all of us know that anytime you transfer money through electronic means. The next slide. Now, what are the gains of e-banking? One, there is no need for us to do what they call branch banking. Before e-banking came, you have to go to the branch where you have an account to deposit money and withdraw money. It was not possible for you to come to Okada here to withdraw money if your account is in Benin or in Lagos. If you have money in Lagos, you have to travel all the way to Lagos to the branch where you have an account to withdraw money or deposit money, but no more with e-banking. They have it called Dishonest Checks Offences Act, 1977. That act made possible checking people who will issue you a check and then the check will bounce. We call it dot check. But now nobody wants to accept that. Transfer money to me, and in a few seconds you get an alert. So that statute is almost gone. Then we have several cases on forged checks. I just want to mention two, Greenwood and Martins Bank. In Greenwood and Martins Bank, a husband had a bank account. And then the wife knew how to forge his check, his signature. So the wife forged his signatures once, 2 times, 3 times, 5 times, 8 times. The husband knew and kept quiet. Apparently, he didn't want to embarrass the wife. So after 8 such forgeries over a period of time, the husband decided to talk to the bank and say, all of these checks you've been paying are forged by my wife. These are not my signatures. They are the signatures my wife forged. Immediately, the man told the bank, and the bank took action against the woman. The woman committed suicide. Even with that, the man proceeded against the bank. That the court held that since you knew your wife was forging your check, your signature, and you kept quiet, you are estopped. Law students know what estoppel is. So the man lost. Now you have London Joint Stock Bank Limited and Macmillan and Arthur. In that case, a manager drew a check. There was a pound sign. If you're not familiar with pound sign, no naira sign. And the man wanted to withdraw just 2 naira or 2 pounds. Now there was a space between the pound sign and the 2. So the clerk who was giving the check to go and cash 2 pounds wrote 1 before the 2 and wrote 0 behind the 2. It became 120 pounds. 2, the man who drew the check did not write the amount in words. He only wrote 2 in figures. So the clerk wrote 120 pounds. And what is more, the man had signed the check. So the clerk was able to go to the bank and then stole 120 pounds. Macmillan and Arthur Limited, that's the owners of the account, the drawers of the check, sued the bank. It lost. The court said, when you are drawing check, be careful. If you are careless, too bad for you. Now, you don't have that anymore today because not many persons draw checks any longer. We use ATM, USDD, and all of that to transfer money. Another issue that is largely gone is measure of damages for wrongful dishonor of checks. All 300 level students here and all lawyers know the case of Hadley and Baxendale. In Hadley and Baxendale, the English court held that the damages you can get are the damages that are foreseeable at the time the contract was executed. So if you draw a check and the check is dishonored by the bank, by the bank, you cannot say, I wanted to pay school fees with the money and then I could not graduate. And so all the consequences, if I had graduated, I will have earned $1 million a month and so on, consequential damages. The court said you can't get that because at the time you drew the check, that was not within the contemplation of the bank. However, this judgment, Hadley and Baxendale, was 1854. In 1830, about 24 years before this judgment, in Mazzetti and Williams, the court has said that if the customer is a person in trade, note the expression. It doesn't say trader. It says a person in trade. If the customer is a person in trade, then the customer can get damages, consequential damages, exemplary damages because of dishonor of check. Now, there is one case that has brought this tremendous favor to Nigerians. And the Vice Chancellor, I'm sure, will be interested in this case because it was decided by Idigbe, Justice Idigbe. That is the Vice Chancellor's, yes, the Vice Chancellor's relation. Of course, all law students and lawyers know that Idigbe is in a class of his own. It's unfortunate that we lost him when he was just about 59 or 60 years old. Now, Idigbe decided this case. This case can enter Holby's Laws of England. It can enter anywhere in the world. Because before this case, even English cases had been saying that the customer must be a trader. Now, there's a distinction between a trader and a person in trade. A trader is a person who buys and sells. A person in trade is anybody who is carrying on commercial activity. So a lawyer who is in practice is a person in trade. An architect and so on is a person in trade. A tailor is a person in trade, not necessarily a trader. So Balogun and National Bank is the first case on the point in the English-speaking world that said a lawyer who is in practice is a person in trade. That judgment in 1978, interestingly, Balogun is a lady, Tarijat. I think she's still alive. Yes, still alive in the 1990s, the senior advocate. She took all the way to the Supreme Court. The next slide, please. Then there's what they call countermand of checks. You can draw a check and say, the check will be paid at the end of May. Please make sure you do blah, blah, blah for me. Paint my house properly. If you do, I will inspect it on 30th of May. Then you can cash the check on May 31st. If the check is dated May 31st. So you can post-date a check. Now, the 30th of May, you find that the man has not done the job. You can do what they call countermand, the opposite of command. Write to the bank, please do not pay. Whenever the person presents the check, you may not be able to retrieve the check, but if the person presents the check will not be honored. With e-banking, you can't do that any longer. In this case, Mom and Barclays Bank, the money was transferred electronically, but the payee, the person the money was transferred to, did not know that the money had hit his account. So the drawer of the man who gave the command, pay, told the bank, reverse the money. I don't want to be paid the man any longer. The bank said it's not possible. the bank money has entered this account and we cannot withdraw it. So he went to court and argued and lost. The court said money is paid once you touch the bullet, the button. There is no way where you can countermand and say, let me have the money back. Even if the person does not know that money is in his account, the money has been paid to him. Next slide. Now we come to the challenges of electronic fund transfer. One of them is that the terms and conditions are not brought to your attention. Usually when you go to the bank, they give you a form, you fill, they give you the ATM card, they don't give you opportunity to read. And even if you read, you can't understand the terms. And even if you read and understand the terms, you can't remember. Ideally, in civilized societies, a copy of the terms and conditions should be given to you, either by way of hard copy or electronically. So you can go through and know what you can do and what you cannot do. Unfortunately, we don't have that in Nigeria. And then, even if you know these are the terms and conditions, there is nothing you can do about them. Why? Because they're what they call standard form contracts. Whether it's UBA or Zenith Bank or GTB or PalmPay, the terms are the same. All the members of the industry ensure that the terms are the same. So you can't say, I don't like the terms of GTB, I'm going to UBA or I'm going to PalmPay. The terms are the same. And then changing the conditions. The banks change the conditions of the terms and conditions without telling you. Next slide. Now, ordinarily, you should get a paper evidence of your transaction. When you go to POS, after transferring, they should print a paper for you. Do they? Yes. But that's the obligation. Sometimes we are too much in a haste to get the paper. Two, the POS operator says there is no paper. Three, he may print you a receipt, and in 2 days, the ink is gone. Those are the challenges you have. And if you don't have that paper to prove that money was there was a transaction, will be difficult because you have to go through the electronic evidence system, which is not always easy. Is the next slide available? And then we'll have also the question of, suppose a wrong transfer is made. How do you resolve the problem? With illiterate, for persons who are not literate, if you go to the bank, you can tell somebody, please fill the form for me. Then you thumbprint, then you withdraw money. But with the electronic system, illiteracy is not known. If you're illiterate, too bad. Now, what do illiterate persons do? They give their card, their plastic card to someone and say, the PIN is 1, 2, 3, 4. The person knows their PIN. So all the person needs to do is steal your card and then go and withdraw your money. Many illiterate persons, many old persons have been victims of that. And so that's another challenge. Then the law does not know anything about consequential damages and consequential losses. So whether you're a person in trade, you are a trader, or you are any customer, the same losses are there. Then this is resolution mechanisms are there, and then recurring of account is not easy. Some of us have experienced this. Next slide to move on. Now in 2018, the central bank rolled out the regulation on instant interbank electronic funds transfer services in Nigeria, 2018. It is not a statute, it's just a regulation of the CBN. So in Nigeria, there is actually no statute that regulates EFT transactions. So it's just this regulation we rely on. One, when there is a wrong transfer due to the bank's mistake, the law says they have 14 days. The bank should make effort to correct matters within 14 days. And then if it is as a result of your own mistake, matters can be corrected within 1 business day. Now, please pay attention. 1 business day is not 1 day. 1 business day means 8 hours from 9 a.m. to 5 p.m. So if you make a complaint at 2 o'clock in the afternoon, 1 business day will end 5 p.m. the next day. 2, Saturdays and Sundays and public holidays are not business days. So if you make a complaint on Friday afternoon, for example, you can't say Saturday is 24 hours, but it's not 1 business day. Your 1 business day will end at the end of a Monday. Those who are familiar with notice to quit in land and tenant matters, for those of you who are in final year, who are offering land law, you know what it means. 1 year means 1 year that expires on the eve of anniversary. 1 month means 1 clear month, and so on. We don't know whether they are going to apply this with 1 business day principle. Next slide, please. So, we can skip this to save time. Now we come to the issue of computer frauds. There are 3 types of computer frauds we want to just mention. One is what they call input fraud. Input fraud means that Chiano, who is a bank employee or a fraudster, transfers money into another account. And then from there, he withdraws the money. We have output fraud, where a fraudster takes advantage of a pre-signed check. A pre-signed check. Then he withdraws it and throws into another account. Program fraud is more difficult. It's not every day, but you should know it. With program fraud, you can do what they call salami slice. Salami slice means a programmer takes 10 naira from each person's account. If we are 300 in this class, a programmer takes 10 naira from your account. 10 naira from your account. Will you notice? Very unlikely. That's why it's a slice. So by the time he takes 10 naira from each customer, assuming there are 1,000 customers in the branch, he takes 10 naira. At the end of the day, he gets 100,000. Is my mathematics right? Yes. Then in 1 month, you don't know that the person is enriching himself. So that fraud, those frauds go on. Next slide. Now we go to the issue of jurisdiction for those who are in litigation practice, including my SAN, who does that every day. Now, somebody may commit a fraud here in Okada. However, the account credited is in Lagos. He's here in Okada, but he's crediting an account that is in Lagos. When he's arrested here, his shout will be, Okada police has no jurisdiction. Okada High Court has no jurisdiction. He may succeed. If he's arrested in Lagos, he will shout in Lagos. The fraud was not committed here. The fraud was committed in Okada. Lagos Court does not have jurisdiction. Now, I'm giving you an example of cities that you know. Of course, some of you know that cities like in New York, somebody can be in New York, in Japan, whatever, and be committing fraud, withdrawing money from your account here in Nigeria. So that issue came up before the English Court of Appeal in Arrow against Thompson. The guy was employed, an Englishman, was employed in a bank in Kuwait, Middle East. And there, he was transferring money. He focused on accounts that were substantial and that were dormant. So he created 5 accounts and was taking money from those accounts, into those accounts, into his accounts. But he programmed it in such a manner that the money did not hit the account until he left Kuwait. So one morning he went to bank, I'm resigning. I'm going back to England. I'm an Englishman. I'm tired of being in Kuwait. When he got to England, he ignited the thing. And the account hit his account, the money hit his account. Pam, 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 pam. So that was when the bank got to know that fraud was going on. He was arrested in England, charged to court. He screamed. The fraud was in Kuwait. English court has no jurisdiction. He won at the High Court. But at the Court of Appeal, Lord Justice May said the stealing was in England. This is where the account was credited, and he was convicted. So those sort of things happen every day. You don't know because you are persons of character. Maybe you know because some of the persons you know are into it. The last slide, I guess. Now, many frauds are committed by bank employees. So banks are obligated to employ only persons of character. That was the bank employees' declaration attention to your lecturers. I repeat, pay attention to your lecturers. They are well trained. I can vouch for that. Many of the professors here went through us in University of Benin. So to see them here, I was really excited to see that these are persons of character who are teaching and grooming you.
Rachano, thank you very much. It's only somebody who's dead that stops learning. I got a lot from your piece. Now, time is right, man. You guys have to go and study, and there are other things to do. Well, let me make a few comments about my learned friend, Professor Oba's paper. I have enough time to finish, but like we said, this starts this Erediauwa seminar series. Whatever has been done here will be polished up and published, including my contribution, which I haven't had today. You haven't had time to hear today, but you'll find it. And we'll start another tradition in this university, at least, Mr. Vice Chancellor, during my visitation. That's Erediauwa seminar series. I haven't said that, sir. I thank very much, Professor Oba, thorough paper. But the problem with this know your customer thing in Nigeria has been presented by the legal profession, and the judiciary has questioned it. Now, you heard about the financial action force that Prof talked about. It came about at the end result of a coordination and cooperation, international coordination and cooperation, intergovernmental coordination and cooperation of the free world to who are suffering the evil of overwhelming corruption and the grim consequences of terrorism, to say, look, if we're able to plug the money, monitor the money, we're able to do something about terrorism. And with that, a whole regime of rules, principles were agreed upon by nations, which in Nigeria's case became domesticated by certain provisions in the CBN Act and the EFCC Act. That's how the Know Your Customer rule came. And before you knew it, it got a challenge in Nigeria by the lawyers. Let me look. I am not letting down my profession or disgracing my profession by saying that lawyers are also part of the money laundering process. Don't be ashamed if you're not part of it. I'm not. It's part of the money laundering process all over the world. If you go to England, many lawyers are going to prison for what? Money laundering. If you go to the US, lawyers are going to prison for money laundering. In Dubai, in Singapore, in France, in continental Europe. So why should we come to Nigeria and pretend as if no, lawyers are sacred? So they went to court with this. The NBA went to court against the CBN when those rules, those Know Your Customer rules, were in place, and lawyers, like other professionals, were supposed to make reports to the school or the CBN or to the banks. But look, the certain transactions from my client of ours are a bit above the A, and I should report it. The NBA went to court. They went to court against the CBN. It was thoroughly argued, and the NBA said the CBN, so the Federal High Court should nullify those aspects of the Money Laundering Act that mentioned lawyers at what they call the designated non-financial institutions. If you're a designated non-financial institution, you are made to comply with these principles, with these rules. And the Federal High Court, in doing that, Federal High Court agreed with them. But in doing that, let me tell you what they did. They said a later act of the National Assembly, which is the Money Laundering Act, was voidable by reference to an earlier act of the same National Assembly, which is either the Legal Practitioners Act or the Evidence Act. I'm sure you guys have all gone through the Nigerian legal system, causing the Nigerian legal system, haven't you? Yes. You will know that under our Constitution, in an act of the can only be a nullity if it does not comply with constitutional provisions. Is it not so? Yes. Now, we are not England, where Parliament is supreme. An act of Parliament in England is equal to a constitutional provision here, because England has an unwritten constitution. But these guys said, their lordships in the Federal High Court said that the Money Laundering Act, sections 5 and 25 of the Money Laundering Act, were nullified because they contravened certain provisions in the Evidence Act, in certain provisions in the Legal Practitioners Act. In some cases, rules of professional conduct. I mean, we turned the law on its head, all in a bid to render lawyers as a special breed. I'm proud to be a lawyer. I'm a special breed, but not like that. No, go to the prison, you see many lawyers there who have stolen. Just like you have accountants who have stolen, you have engineers who have stolen, you have architects who have stolen, you have toxicologists that have stolen. That's my joke. So the CBN went to the Court of Appeal. CBN went to the Court of Appeal, expecting that if for anything, our constitutional precepts must be upheld. If you want that to be the law, if you want lawyers to be excluded, you don't construe the present state of the statutes and gift them what the law didn't give them. You go by way of advocacy, by way of you go to the National Assembly and say, look, please amend this law. Lawyers shouldn't be like this for this reason, for that reason. They didn't do that, but the Federal High Court gifted to them. And when they went to the Court of Appeal, the Court of Appeal agreed with them. The case is now in the Supreme Court. I happen to be the lawyer who's arguing it. So, thank you very much for being good listeners. We hope that you guys have learned something, and you will show us that in the next 5 minutes. We'll give a short time for questions to be asked. The faculty is available. I'm also available if you want to ask me questions. I think the first person who will ask questions will be your Vice Chancellor.
Thank you. Let me. No. Yes, don't worry.
No, so the Vice Chancellor will take over from me now. Our job is done. Thank you very much.
Well, thank you very much. Thank you. So, you okay? Well. This is another feather in the College of Law. Just like Professor Chanu said, the entire management of the university is proud of the College of Law. I'm not sure you heard me. And if you know me very well, I don't say what I don't mean. What we have seen is an innovation, and it's apt and timely too. The reason is very clear. The world is changing fastly, and the academia also have to adapt with the changing world. And this is exactly what we are doing now. I don't do that with an empty brain. It's through creativity and innovation. So we accept and adopt the College of Law seminar series. So, we are listening to privileged to listen to 3 different scholarly papers today, which is very, very unusual. For me, I've just been told today by Professor Chanu that money in the bank belongs to the bank. That's an irony of fate. As a matter of fact, that the owner of the money must put a demand for payment by check. Banks are also admonished to keep secret. Do they really keep secret? I would like to ask the very first question before I conclude my remarks. Let it be on record that I asked this question. Is the bank supposed to use frozen money to do business? I've not asked you. And so don't send anybody after me. You see, the other paper was on the KYC, know your customer. And you see the elucidation from the Sun on the fact that even Shakespeare said that we have a problem when correction lies in the hands of those who make the fault. I rest my case. If lawyers who are supposed to be protecting us are trying to dislodge the law that protects us. But today we have a 1 in 3. That's what I've captioned today's outing. A 1 in 3 outing. It's huge. The e-banking, Professor Shannon, you see, when you talk about forged check and suicide, it's dramatizing it to absurdity. Forged check, suicide. I know that way back, as a very little accounts clerk in 1974 at the Tri-City Bus Service in Forestry. Yes, I was an accounts clerk. So we were taught to write in words and figure. You write 1 naira, you write it in words and bracket. These days, people are very impatient. So the propensity for crime in that area is wider. But again, I'm worried with the consequences of e-banking. It took my bossa and the entire management of the University of Benin, of Erediauwa University, to get me to have, what do you call that thing? Card. What do you call that thing? ATM card. It's a recent thing. I belong to the old school. And I started banking in 1981 with Barclays Bank. That's Union Bank. That's to tell you how local in terms of banking ideology I am. In my house, my kids, they call me Lokito because everybody has this ATM card. It's only me that still carry check about. But the reason is very clear. The consequences associated with e-banking. There is no, I want to ask you now, are there laws to protect the customers? None from what you have presented today. You gave us an array of consequences. So what are the laws? So it's on this note we shall take some questions, 2 from here, 2 from here. But remember that I asked 1 question. Is it proper for the bank to use frozen money to do business? That's number 1. And number 2, what is the position of the law to process the customer in e-banking? Thank you.
My Vice Chancellor, thank you very much for those brilliant comments the bank is at liberty to use frozen money to do business. And the reason is that the money belongs to the bank. If you remember in my opening comment, once money is lodged with a bank, the money becomes the bank's money. It is a fiction, but legal principles are based on fiction. So the liberty to do business with the money. The bank's duty to return the money to the customer begins when the customer draws a check. So if the credit balance remains frozen for 5 years, 10 years, 20 years, it remains the bank's money and the bank can do business with the money. Of course, you know that the money is not like tangible like this. The money is a fiction. It's just credit balance. So at the end of the day, what is the credit balance with the bank? What we call liquidity ratio between the bank. And when the CBN looks at your books, they will find 200 billion naira. Part of the 200 billion naira may be 10% of it may be frozen money, but it's not reflected in the books as all between the bank and CBN. So the bank is at liberty to do business with it. As for the consequences of the negative consequences of e-banking, caution. In this country, the first rule is caution. Self-serving caution. Do what you can to protect yourself. Because at the present time, there is actually no statute. And even if the laws are there, remember you go to court. Last week, the head of the Court of Appeal, Lagos, the presiding judge, Court of Appeal, Lagos, said there are 18,000 cases pending in Lagos division alone in the Court of Appeal. 18,000 cases. There are over 30,000 cases pending in the Supreme Court. Now, if you have a matter with the bank will not relent until it goes on appeal. And this is the reason. The bank has retainers who are lawyers. Even when the bank does not have a good case, lawyers will say, sue the bastard or defend against the bastard. And the bank, I hope there's no banker here.
No.
In the legal department, this is an investor environment. I can say what
Go ahead. Yeah.
In the legal department of the banks, there are lawyers who feed out these cases to lawyers in the field.
Okay.
Now, those persons in there get their own ilalobo.
Yes, sir.
You know what I mean? So even when the bank has a poor case, they will just say, go to court, go on appeal, and so on. So the courts are flooded. So when a weak customer, and most customers are weak, you are ready to fight against a giant,
No.
against a heavyweight champ? No. So in many cases, customers just fizzle out. And then they abandon the case because they do not have the funds to fight cases against banks. And then this environment, an environment I can speak. I hope I'm not on tape.
No.
And if you notice, most of the cases, it refers to one bank, Barclays Bank. Does that teach you anything?
Yeah.
God bless you.
Thank you. Yeah, thank you. Thank you very much. Thank you very much. You see, the debate will continue. The debate will continue because I'm still very worried that the customer's money belongs to the bank. We'll leave that. You see, because in accordance with, you see, that's why you have many unbanked funds. In accordance with your legal practice, is it not proper that the bankers will also give a caveat to the people? Let the buyer beware that if you are bringing your money to my place, it's no longer your own. That's for a debate for another day. Yes. That's for another day. Caveat is not only for selling of land. You should also let the people know Am I making any point there?
Well, Professor Chano already said the cash deposited by the customer belongs to the bank.
But
the customer has something, the credit balance. The customer has the credit balance.
you see,
So anytime he wants to his money, he takes it from the credit balance. So that is it.
I say it's a debate for another day. The law college find somebody on PhD, somebody in PhD or masters, and put them on this thesis for discussion. Yeah, look for a topic from a postgraduate program topic must come out from this seminar, right? Because all our postgraduate programs are supervised by those in practice and those in academia. So I'm sure our speakers today will have one postgraduate student to supervise on these great areas that have concern to us. So I'll take the first question here. All right, one there, you there, the lady behind. So you are one, you are two. And here, who is the first to raise? Which? Okay, three. Where's the fourth person? Okay, behind there, four, right? Okay, we are good to go. Yeah. There's no commentary, just question.
Yes, thank you very much for this wonderful topic.
You introduce yourself.
I am Eric Bimi, 400 level law student.
Yeah.
What I really want to know, because the two natural pillar of justice is audio terem partem and nemo judes in causa as well. That you must give fair hearing to this person. But marrying these two things together, that you will just go to somebody and forging someone's account that you suspected that the person has what they call money, drugs, money, or some money that are not this thing. How can we marry these two things together?
Okay.
You can't hearing from the person, you don't know where this thing come from. By giving power to these people, we all know Nigeria today, if you give power to the police, they will do more than what is expected of them.
Don't go there. You have asked your question. Conflicting legal maxims, right? Okay. They will answer it. Who was
Second question.
Then take the second question. We have noted this first one. The conflicting legal maxims, right? Uh-huh. Fair hearing.
Okay. Good day, House. My name is Okori
There's no
Manuela.
house here.
Okay. Good day, everyone.
Yes.
My name is Okori Manuela, a 400 level law student. So my question goes, Okoro Emanuela,
Okay.
a 400 level law student. So my question goes like this. Okay, what if there's a situation whereby you were convicted of an offense? You were convicted of an offense, and maybe the court actually ordered a freezing of your account.
Mm-hmm.
So maybe after your conviction, and maybe you were actually released, so you now went back to your bank and asked for your account. So what are the procedures for you retrieving your account? Thank you.
All right. Yeah, without preempting the answer, the conditions of release will also be in contention. Whether you are released on bail or acquitted, if you are not, well, he will answer. Is the terminology is there, he will answer. Is the authority. Okay, number 3. Yes, the lady there.
Good afternoon, everyone.
Is that the AG?
No.
Okay.
Okay, good afternoon, sir.
Yeah.
My name is Henry Young Splendor. I am a 400 level law student.
Okay.
And my question is this. When Prof was talking, he was addressing the question that the Vice Chancellor asked concerning the dangers with the e-banking. And as we know, the world is evolving.
Yeah.
Literally uses checks anymore, like my generation. It's more of transfer. And I think shouldn't there be more laws to protect us in this case? Because now we have situations where they take charges for card management or card maintenance, and I'm like, are you cleaning the card for me? What are you maintaining in my card? And shouldn't there be more laws to protect us in the sector or the sphere of the e-banking?
Thank you.
Thank you.
You see, I have a supporter which I raise a vanguard. Thank you. The fourth, please, fourth and the last. Yes, that's in behind. Thank you. Thank you. It's becoming very interesting and lively, I guess. Yes, please introduce
Good
yourself.
afternoon.
Yeah.
I'm Adole Israel from 300 level. And thank you for this opportunity. My question is, how can Nigerian banking law justify the balance between customer confidentiality with the need for transparency in criminal investigation?
Fantastic. 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 Churchill, please, you heard him, right? Say, you heard him. You didn't hear what he said. Why? You don't understand English? No, he's not going to say it again. We have heard him. Those who heard him will listen to the discussion. If you did not hear, you were doing something, you were pressing your phone. Somebody said here, thank you very much. Professor Chairman.
I thank you, Eric, for your question. Every rule, most rules have exceptions. The fair hearing principles you espoused have exceptions. Now, if an account is frozen, it is not frozen forever. Whatever anybody may say, self-help is a fundamental principle and remedy in law.
Okay.
Now, when an account is frozen, if you follow the lecture, there's a statute that says you may freeze for 3 days, 72 hours. Now, within those 72 hours, they find that there is nothing irregular in your account. It is unfrozen, and you carry on your commercial transactions normal way. That is one safeguard.
Okay.
2, the general safeguard, if you follow the lecture, is that you have to apply to a magistrate or a judge before an account is frozen. So it is possible for the police, out of enthusiasm, not just the police, law enforcement agencies, out of enthusiasm, to freeze Chianu's account and Mrs. Chianu's account. The bank says, no, the person you are investigating his account is Chianu. I'm not going to freeze the account of Chianu and Mrs. Chianu. Lawyers are trained to apply such principles. The problem we have is not the law. Somebody is talking about let's have more laws. That is one problem we have in this country. Let's have more laws, let's have more laws, let's have more laws. The problem is enforcing the laws. 2, having persons of character to enforce the laws. If persons of character enforce laws, some of these principles, they are working in some other parts of the world. And in the course of my lecture, I did mention that we must decide what we want in this country. Do we want privacy, accounts inviolable, immune, secret, confidential, untouched? 1. Or do we want to fight crime because of public policy, public interest? We can't have it both ways. Of course, we can have a middle course, but we can't have it both ways. What you're advocating is privacy, confidentiality of accounts. If we have that, all the fights against what you call internet fraud and so on will be lost. Yeah. So we can't have it both ways. That's my answer. Basically, fair hearing remains. if you're in 400 level, you must have heard of ex parte applications for an injunction, a interlocutory injunction, if you have done first semester equity. So you have an ex parte application, it is granted for 7 days, and then within 7 days, you now go back interlocutory. So during those 7 days, there is no breach of fair hearing, because you know that after 7 days or thereafter, you can now go and have your fair hearing. So that's basically the attitude. In almost all civilized jurisdictions, bank accounts are frozen for a short period. You can't have an account frozen forever. So it's frozen for 3 days, 3 months, blah, blah, blah. After that, it will be unfrozen. It is assumed that before the end of that period, all the investigations will have been concluded and the account will be either unfrozen or frozen until the end of the case. I don't want to mention this. Perhaps you have a lot of Anton Pillar order in your equity class, injunction class. If courts do not have authority to ensure that assets of litigants are kept from being stolen or taken away during the jurisdiction, everything the court does will be lost. I'll give an example. My Vice Chancellor, give me a minute to explain this to everyone. Now, sometimes husband and wife are in court. The husband wants to divorce the wife, or the wife wants to divorce the husband. At the end of the proceedings, one of the things the court has to do is to share their property. Yeah. They call it settlement of property. Now, what the property owner, let's assume the man owns the property. The man knows that at the end of litigation, my wife will have access to some of my property. So what does the man do? He sells the properties. He transfers the properties. He can give the property to girlfriend, side chick, my mother, my father. At the end of the day, when judgment is given, after 3 years, 5 years, 7 years of proceedings, the court says the first house in Port Harcourt goes to the wife. The property has been transferred by the husband 3 years ago, 2 years ago. So in Sydney and Sydney, it's in the paper that I gave the business professor, which we published later. 1867, the court said no. Once a matter is in court, neither spouse can transfer the property. So you have property right, but the court says you cannot exercise the property right. In the same way, Justice Balogun in Retrade Bank, one of the cases I mentioned, Justice Balogun says once a matter is in court, even though police does not bring a paper, the court has the jurisdiction to freeze an account until the end of litigation. Otherwise, the customer will withdraw all the money and all the litigation will be lost. So that's a fantastic judgment by Balogun. It's unfortunate that Balogun entered the bench when he was already an old man. He was in his 50s. So he didn't write to the Court of Appeal. But he was a great judge. He was trained by Rotimi Williams. He worked in Rotimi Williams' chambers before he became a High Court judge. Emanuela is asking, so if somebody is convicted, after his conviction, does he come back to his loot? Very likely, at the time of judgment, the court will make consequential orders with regard to the money. If the money belongs to Emanuela, for example, what's the name of your friend who is sitting next to you? Let's give her a name, Lydia. If Lydia has stole the money and Lydia is convicted, by way of consequential order, the court will say Lydia or the bank transfer the money in Lydia's account to Emanuela. And then she goes to court. She goes to prison. When she comes back from prison, the money will no longer be in her account. By way of consequential order, the court will have done that, transfer the money from the account of the fraudster or criminal or convict to the rightful owner. Or if the money, they don't know where the money comes from and so on, it cannot be traced back to the state. Then Henry's question is about, we want more laws. I've mentioned that. We don't have problems with laws. I can say that 100 times. When the EFCC Act was enacted in 2004, there was a seminar organized. Professor Lawrence Asebua, SAN, was there. I was also invited. We did an EFCC Act. Most of the provisions there are already in the criminal code. Most of the provisions there are in criminal code. If the police does its work, you don't need an EFCC Act. True, new frauds are coming on, may not have been protected by the criminal code, which is 1914 or 1916. But likely, if we have an effective law enforcement system, we don't need more laws. We want people of character. I repeat, people of character. The visiting professor has mentioned that even lawyers are contributing to the weakness of the legal system and judicial system. So if we have a good system, we don't need more laws. There is a Federal Consumer Protection Commission where people can run to. I see that each time I make transfer, I lose 26 naira, I lose 26 naira, I lose 5 naira, I lose 20 naira, and so on. Why? That commission should take it up. It should take it off and then approach the court system, approach the banking system, and check it. There are a few cases where lawyers have gone to court. I know one, Airtel. From nowhere, they would
Increase.
give you advert. Sometimes you are making call, an advert comes in, unsolicited advert, and so on. The lawyer in Bayelsa State went to court to get a court order to stop Airtel from doing that. So somebody is saying that pro bono litigations are dying because you can't use pro bono to send your wife to market.
No.
You can't use pro bono to pay school fees.
No.
You can't use pro bono to fuel your car.
No.
But in those days of Carnival were in me, Tommy Falana recently and so on, several lawyers have hit the limelight through pro bono activities. If we have persons who go to court and the courts are willing to listen, by the time you go to court for a simple matter that will be resolved in 12 months, 1 year, and you are there for 10 years.
No pro bono.
Adjournment, while election petitions are hard speedily.
No.
Listen, I've said enough.
Okay, thank you. Okay, let me hear from you. We are rounding off now, so don't worry.
Okay, thank you, Mr. Vice Chancellor. I just want to add that, in response to Emanuela's question,
Yeah.
asset forfeiture, like Prof said,
Yeah.
recognizes the importance of fair hearing. When a person is charged with, for example, money laundering, and he comes to court, they do asset tracing. All his houses in Lagos, Abuja, wherever, they will trace them. If at the end of the trial, the person is convicted, there's a law that says the asset will be forfeited to the federal government because it is proceeds of criminal offense, proceeds of money laundering or terrorism financing. So, but if at the end of the day, the person is discharged and acquitted, of course, he gets back his asset.
That's what
There's one now, somebody, a former official.
A former. Leave it at that again.
So, over 700 property
Forfeited.
to the federal government. So that's it.
So what he just said, if you are used to Nigerian news, you know about that.
Just want to say something.
Please, go ahead.
Mr. VC, sir, thank you, sir, for the opportunity. I want to also appreciate our teacher, Professor Emeka Chianu. You see, when your account is frozen, the practical aspect, if you know that the bank ought not to have frozen your account, and there's an ex parte order, usually they go to bank to obtain an ex parte order. All you simply do is you go back to the same court, ask that ex parte order be set aside.
Vacate it.
You can go back to court. You don't even need to wait. There's no issue of denial of fair hearing or no fair hearing. Once an ex parte is obtained, you go to court and say, okay, you want that ex parte for these reasons and for that reason. And of course, if the court listens to you and you have a good reason, the court will usually set aside such ex parte order. We have done it, we're still doing it, and we will do it. Thank you, sir.
All right. Well, thank you very much.
The young man who talked about conflicting mantras of fair hearing. Did you say Namujidex in Kasaswa or Audi Outeran Patem? Okay,
Yeah.
Whatever it is, these are twin pillars of principle of fair hearing. But don't always forget that you must locate it in a democratic setting. There are exceptions to these principles under provisions of the Constitution, but they must be located that as things reasonable in a democratic setting. God forbid, if you've never had a relative killed by an armed robber, whose rifle was bought through the proceeds of crime, laundered money of crime, or you've never gotten killed on a badly made road, whose monies were embezzled and passed through and laundered, and you won't know what I'm talking about. But like we said, like Vice Chancellor said, programs like this are to show the pragmatics and practicals of all the book things we'll be learning here. If your assets are frozen temporarily, you can't, for you to also have opportunities like your prof said, like the other prof said, for you to go back and revisit them, it is not unreasonable in the circumstances in a democratic setting.
Thank you.
You must not forget that. When you learn precepts, also know about their exceptions, know about their contexts, and how the different provisions of the Constitution relate to each other. Nothing is ever straightforward. Once it is allowable or reasonable, that is the word of the Constitution. In a democratic setting, it is allowable.
Thank you very much. Thank you. Thank you. Thank you. You see, there's always room to give opportunities to innovation. Have we enjoyed today's series? I cannot hear you. Some people are still not affirming. You sure? I will lead you to one secret before you go. But one of fair hearing. I will tell you. What demands our care now is to make official presentations to our speaker, but starting with the guest speaker. It is customary at occasions of this nature that we make such presentation. So I would like to invite Professor Charles Edoson to make this first presentation.
Please, can you give him a round of applause as he receives a presentation from the Vice Chancellor?
We still have these souvenir to present you, but more importantly, I'm really present to the story of the text.
Please, can we give him a round of applause, please?
Please give me a round of applause. Thank you.
I would also like to invite Professor Emeka Chanu to come and receive a presentation from the Vice Chancellor. Please, can we give him a round of applause? Also, Professor Nelson Ojukwu is also going to receive a presentation from the Vice Chancellor. Please, can we appreciate him?
Thank you very much.
Please, another round of applause for him, please. Thank you very much. Thank you very much. This point in time, I'd like to invite
Okay. Okay, let's read it. I will next time. We're going to do that for the problem, but I will also talk about the question of
Thank you very much. Please, music, please. I'd like to welcome to the microphone for the vote of thanks on behalf of the registrar, Mr. Olugbenga Jegete, the Deputy Registrar, Academic Affairs. Please, can we give him a round of applause?
Before he gives the vote of thanks, I promise I will let you into one secret. Are we ready to hear that? Only those who answer will benefit from it. The visiting professor or guest speaker on its own has provided refreshment for all participants. Hello. You see, I'm a messenger of good news. And this next time when I invite you to any program here, make sure you come in large numbers. Thank you.
IUO, Vice Chancellor, sir, may I seek your permission to remain on the protocol already established? This afternoon, I'm proud to be a lawyer. I said, this afternoon, I'm proud to be a lawyer. I know my friends in medicine will be jealous of me today. Yeah, some of you are wondering, I'm not a lawyer. I'm just married to a lawyer. So, I mean, so a lawyer's husband is a lawyer, isn't it? On behalf of management, we want to thank you for coming to this occasion. We want to thank most especially the Vice Chancellor for giving us the opportunity to assemble here. He has given us the wherewithal. He has given us the platform to be here. We want to most especially also thank our lecturers. Firstly, I'll start with His Lordship, Chief Charles Edosonwa, who has found time to be here. We will not forget Professor Emeka Chianu. We will also not forget Professor Ojukwu Ogba. Most especially, our thanks will go to the faculty of the College of Law and the students most especially. Your comportment, your timeliness, we are proud of you. You have shown why we wear white and black. I said, you have shown why you wear white and black. Your attitude, the questions you have asked, they are stainless. That's why you wear white. Congratulations. We want to also thank the university community for finding time to be here. We say this lecture series that we have started will blossom. Thank you and God bless you.
When did you come back? Quickly.
Please, can we have some quiet, please? Please. Please, law students, please, can we have some quiet? Thank you very much. At this point, I would like to invite us to rise for the closing prayer. And I also want to welcome any Muslim faithful who is here that want us to give I want to give us the closing prayer to the microphone, please. Any Muslim student here present, walk to the microphone and give us the closing prayer.
Good afternoon, everyone. We thank Allah for a memorable day, for an insightful day, for an educative day, for an informative day. We thank the organizers. We are grateful for the Vice Chancellor. We are grateful for the Dean. We are grateful for the honorable lecturers. We are grateful for the guests. We pray that this knowledge becomes impactful for us. And then we pray for safe return to our dwellings and our abode. Please, I urge the Muslim faithfuls to pray with me. Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alameen. Ar-Rahman Ar-Rahim. Maliki Yawmiddin. إياك نعبد وإياك نستعين اهدنا الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين آمين.
Please, we are going to take the university anthem and the national anthem. Thank you. Thank you very much. Kindly remain on your seats as the Vice Chancellor leads the team outside to the foyer for the group photograph. Law students, remain on your seat. The refreshments will get to you. Remain on your seats. The refreshments will get to you, please.